Baker to announce the invitation.
Stand, please. Our gracious Heavenly Father, let's thank you for this day that we can come together and do your work and bless this food to nourish our bodies and give each and every one traveling grace as they leave these meetings today and make each and every one a blessed Thanksgiving. In Jesus' name we pray. Amen.
This time I'd ask Shelley to call roll.
Meredith Braley. Bill England.
Here.
Bill John Baker.
Here.
Jack Baker.
Here.
Harley Bezer.
Here.
Julia Coates. Here. Bradley Cox.
Connie.
Peter Crittenden.
Here.
Jody Fishinghawk. Here. Janelle Fulbright. Don Garvin. Chuck Hoskin Jr. Anna Gloria Jordan. Present. Curtis Snell.
Here.
Chris Supp. Kara Cowan Watts.
Oh, honey.
We have a quorum.
Thanks, Shelley. At this time, we'll have a discussion and possible action of amendments to the election code, and everybody can continue eating. So we'll turn it over to Todd. Right there.
Thank you, Mr. Chairman. First, I would like to recognize, I believe, a complete, soon-to-be complete members of the Cherokee Nation Election Commission. Thank you for attending, and this will be one of many sessions that I hope that we can get together and go through this process. We picked up where we left off, which is on apportionment. It is Section 5C of the Election Code. The amendment, the purpose of the amendment is to bring it in line with the individual districts that we have passed and will become effective in 2011. Right now, and we'll discuss this more fully in rules, but for the Election Commission's edification and for the councilors who haven't got a chance to read it yet, a lawsuit was filed yesterday by the principal chief against the Cherokee Nation Election Commission. So, congratulations, you got your The purpose of that declaratory judgment action is to answer three basic questions. Mr. Chairman, I believe we got a question.
Did they name the present commissioners and other commissioners to be named later?
No, it just said the commission. So,
okay.
So you jump on in. The water's fine if you're not a member yet. But at any rate, the purpose of the lawsuit is to answer the following questions. Number one, is the district apportionment that we passed creating individual districts, I think it's Legislative Act 1408, is it constitutional in that is it a reasonable apportionment of citizens among those districts? Number two, what term are the elected officials on in accordance with the 1999 Constitution that were elected in 2007 and coming up in 2011? Are you serving your first term under the 1999 Constitution, or are you serving your second term under the 1999 Constitution? The third question is the staggered term system that was developed by this council and signed by the chief in Legislative Act 7077 constitutional in that it created a system of 4 and 6 year terms. Also, the suit asked the question of whether the Constitution requires 15 individual districts, or can there be districts with multiple seats. Those are the four questions that the principal chief brought forward. It is substantially the same questions that we would have brought forward. To be honest, I think that the lawsuit that he brought was far too combative and antagonistic for a declaratory judgment action. I would want all the counselors to read it carefully over the next few days. There are some actions that we're going to need to take as a council, and there may be actions that individual counselors would want to take to expound their own views as to how these questions should be answered. But I thought I needed to say something about that prior to going into the amendments here today, because, well, the first amendment that we're dealing with is apportionment, and that obviously has something to do with the lawsuit that is pending. I don't expect to have a lot of questions about the lawsuit, since you all have not got a chance to read it. But as you go about studying it and have any questions, please feel free to give me a call. Okay.
Thank you, Mr. Chair. What is the process then for declaratory judgment? We would enter friendly, or we just, is that amicus brief, or?
Well, this is the way I would see that it would play out. I think, number one, that the council as a whole needs to join the lawsuit as a necessary party, and that we answer the lawsuit in that regard. Secondly, I don't expect all the opinions of each counselor to be the same as to how these questions should be answered. This is where, under the 09 budget, each counselor has $25,000 in legal fees that they can access to get individual answers, and possibly individual amicus curiae briefs or friend of the court briefs. So there's a couple ways that I foresee it happening. Number one is the council joining as a whole as a necessary party, and then, if necessary, individual counselors doing friend of the court briefs, espousing their individual views.
Thank you, Mr. Chair.
Joey.
Question, maybe silly. If he didn't agree with the staggered terms back when they done them in 07, why didn't he just veto it?
Well, I mean, that's obviously all options are available to us, but I am chagrined to a point that if you're now filing a lawsuit saying that is an unconstitutional act, I am at a loss on why in February of 07 you signed that act without even any reservations. But I don't want to get prematurely into litigation strategy or any kind of answer, because we just got, we haven't, well, we're not a party, first. And secondly, it was filed yesterday afternoon, so.
Councilman Garvin.
Todd, in the last election, certain people were elected for so many years. Would that overturn that election? Could the court do that?
Anything's possible. The court could do any number of things, so I can't tell you that that's not possible. What I think is that if the court were to say that was an unconstitutional term, that they would just shorten the term, and they would come back to the council and say, find another way to do it. I don't, and we've had this discussion when we were passing that act. The Constitution says four-year terms. The Constitution also says that within a year that the council is to implement a plan of staggered terms. And also, we are under a court order to implement a system of staggered terms within a year. Now, the only two ways to do it is to have a 2-year term, which someone could easily come say, well, that's unconstitutional, or a 6-year term, which someone could easily say that's unconstitutional. The council, after great debate, chose a 6-year term, and I think under the mandates that they are under, both under the 99 Constitution and by order of the court, I do not see that the court would overturn that act. The only other way to do it is simply not to elect certain councilors or certain council seats, which would leave people unrepresented, which would be a far greater detriment to the public than by not being represented. So I feel very confident on the 6-year term because, number one, we had to. Yeah, we absolutely had to.
So you're going to take active part in defending? group?
Yeah, what I'm going to proceed, and we can take a formal action in a full committee. But my idea is to proceed is to, number one, do a motion to join as a necessary party and expound those views that obviously all the council agrees to. I mean, the council by a two-thirds majority said that the representative districts were correct. The council by unanimously said that the 6-year terms were correct. Those, there's no debate on those two as to the council's view. Now, obviously, there may be some differences of opinion as to whether you're on your first or second year term. We will, we can have a view of the council as to the majority, but if there's a minority in there that thinks that you're on your second term, well, that's where you come in with your 25,000 and expound those views.
So our instructions to you needs to come pretty soon.
I would want maybe even at the 1 o'clock meeting to amend the agenda to discuss that, to give me some direction to start on this immediately.
Thank you, Mr. Chairman.
Okay, continue on, Tom.
Okay. Section 5, C. The amendment would read as follows. Apportionment of representation having been first conducted in 1990 shall be conducted every 12 years thereafter and shall be concluded not later than June 30 of the year preceding a regular election. Apportionment shall be conducted by the Election Commission and approved by the Council by amendment of this section. Said apportionment shall be obtained by first dividing the combined total population of all, and we strike members and put citizens of the Cherokee Nation residing within and we strike historical and add jurisdictional boundaries of the Cherokee Nation by 15. That's our new number of seats. This figure must then be divided into the total population of all the strike members put citizens of the Cherokee Nation residing within each district. Period. Okay? And then we would strike the last two sentences of that section, which the stricken portion would read: the resulting percentage shall determine the number of representatives per district. The reason we strike that is that we no longer have numbers per district; we have individual districts. All percentage points 0.5 or higher shall be rounded upward to the nearest whole number, and all percentage points less than 0.5 shall be rounded downward to the nearest whole number. So therefore, that's stricken also because that deals with districts with multiple seats. So we strike that. We also would strike in this amendment the entirety of subsection D of Section 5, which deals with in counselors having 2 or more council seats by apportionment, etc. That's the basics. The basis of this amendment, like I said, is to bring it in line with Legislative Act 1408, which has us individual districts. That's my explanation, and would welcome any questions.
When would that mean our next apportionment would be conducted? We started in 90, we went to 2002, and we're going to do it every 12 years, is that right?
We can do it every 12 years.
So we're in 6 more years.
6 more years. Or if you wanted to put language in there, every 12 years or whenever the council deems appropriate.
And should there not, Todd, should we not consider putting something in there about when or is this the appropriate place where there should be like a deadline for determining how the redistricting? Instead of getting into like what's happened here, we've missed one election on redistricting. We're coming up on another election. Now we've got this lawsuit. Shouldn't there be something within these rules that says you need to have your redistricting complete by this day? Failure to do so, we'll turn it over to the court.
Well, this is the section that is meaning to do that.
appropriate.
Yeah, that says, by
But it
no
doesn't-
later than June 30th of the year preceding the regular election. So
Is
that,
that really giving us enough time is that giving the election board enough time to do all the things they need to do after we get done with our part?
well, let's see, our next election is July of 2011. So by June 30th of 2010, if this was a year in which apportionment would happen, I would recommend that we put in some language about or whenever the council would deem appropriate. But every 12 years, we're supposed to have apportionment. You're supposed to have that apportionment done and districts set, or seats per district. That's what that's why we deleted all the other language. But you need to have all that set by at least a year before or 13 months before the next election, June 30th of the year before.
So is there any way that how are we going to be sure that the court's going to have taken this lawsuit all the way through the system, made their decision, and told us if they don't like what we did, that they give us direction so that we can go back and do it again? We're already a year out, and this is saying it should be done a year before, so we have a 2-year window here, and my experience with the court is that sometimes 2 years is not enough.
Well, I would agree with you. There are no assurances, okay, of whether there will be enough time. I will tell you, I had a conversation last Thursday when we had our meeting. That's why I was running back and forth. There was a Supreme Court meeting, one of their quarterly meetings, and I told them to expect a lawsuit concerning these issues, and their reaction was, the election's in 2011. Why would want to bring something so early? I said, well, because, the court, sometimes takes a while in answering these lawsuits. And that is precisely why we have started on this process. The chief has filed his lawsuit, like I said, in his own fashion, but you had already given me a direction to work with the Attorney General to develop these same issues. That's why we wanted to do it early. And hopefully we will, hopefully we won't have that problem. But the only thing we can do in this election, or in this statute, is to set some type of date. And right now, that date is June 30th of the year before. And I think 13 months is to have a 13-month deadline is good, because you don't want to have major changes or disruptions in your election process only a few months or weeks prior to filing, or even after filing.
That's not giving them 13 months, though. The process for an election starts in the spring. So that actually is giving them 6 or 7 months. That's all the window that they have to make the needed changes through the election commission to comply with redistricting.
Yeah, you're right. Because you're going to be filing in March. Filing in March. But I'm obviously open to anything that the council wants to do. But that's the date right now.
I do make the motion that we make the change or
as deemed appropriate by the council every 12 years thereafter, or
Motion, you're putting that
yes,
forward
it's
as
a
a motion?
recommendation of Todd. I would make that motion.
Okay, good. We have a second, or do we need, or is it just a recommendation for you to do that, Todd?
Well, this is what I would, let's go ahead and have a second and vote on it. That way it's in there or it's not, and we proceed on to the Rules Committee.
Exactly where would you propose?
I would put that right after said shall be conducted every 12 years thereafter, and after that, or replace that comma, or when deemed appropriate by the Cherokee Nation Tribal Council. And shall be conducted not later than June 30th, blah, blah, blah.
Have a second on that? Any questions, Jack?
Yes. This means that it will still be every 12 years, or as deemed appropriate.
Correct. The requirement of 12 years.
Because the requirement still stays.
Yeah, the requirement still stands. We're going to have it every 12 years or whenever, or when deemed appropriate. Because you might come into a situation where there's a major population flux, and you know that, year 6. You don't want it to wait 6 more years.
But I didn't want to do away with the 12
Right.
years.
No, the 12-year requirement still be.
Any more questions? Okay. All in favor, say aye.
Aye.
All opposed? Hearing none, passed. Okay, Todd, continue.
I would continue. I guess the only other question then would be is you want to stick with the June 30th date or pass the pass 5C and D as is?
Don't need to change the name.
Julia?
I would make a motion to move it to March 1st of the year before. That will give the Election Commission a full year before the filing date even.
I second that.
Okay. Have a motion, have a second. Any discussion on that? No discussion, all in favor, say aye.
Aye.
All opposed? Hearing none, passed.
Yes, sir. Unless there's any other questions on 5C, we need a vote on whether to adopt it or not.
Okay, do I hear a motion to adopt 5C as amended? Move to adopt as amended. Second. Any discussion? All in favor? Aye. All opposed? None.
Okay, the next amendment is dealing with Section 21 of the Election Code, and it would create a new Section 21, subsection A, subsection 4. So this would be an entirely new section. This title 21 is titled Eligibility to Vote. Okay, the new section would read as follows: persons convicted of a felony under the laws of the United States of America or any state, territory.
Councilman Tom? No, just go ahead and finish.
Oh, okay.
When he's done.
Oh, okay. I'm sorry.
Oh, okay.
Persons convicted of a felony under the laws of the United States of America or any state, territory, or possession thereof, or convicted of a crime in any tribal court of any federally recognized Indian tribe that would be considered a felony in state or federal court, unless such person has received a pardon from an unauthorized official of the jurisdiction in which the conviction was received, shall be ineligible to vote. The purpose of this is if you are a convicted felon without receiving a pardon, you would not have a right to vote. Currently, you do have a right to vote.
Brad, I'm assuming if you're ineligible to vote, you're ineligible to run.
Yes, that is already a requirement to.
Just making
Yeah.
Is that all, Brad? Yes, thank you. Okay, Janelle?
I am strongly against the vote. I think felons serve their time in the penitentiary, they get out. I know too many convicted felons that feel like they're totally left out. It's so hard for them to get a job. I think they've done their debt to society. They should be allowed to vote. And I disagree with the Oklahoma law. And I think felons should be allowed to vote. How long ago we keep on punishing people?
Is that all, Janelle?
So, thank you, Mr. Chairman.
Jody?
I'll just echo Janelle's sentiments and bring up that Oklahoma felons are allowed to vote after they've done an equal amount of their original sentence. That's all.
Julia?
I just want to affirm that also. People, the process is far too much about punishment and not enough about rehabilitation. I think this is a good rehabilitative thing to bring people back into civic activities to allow them to vote.
And I would like to echo what the ladies just said too. That's exactly the way I feel. John?
Well, and how much burden is that going to put on our election commission and they register to vote? I tell you, they're not a judge, So the ones that want to get around it can. And we're not going to have the police out there trying to figure out who is and who isn't. I just think we'd be creating a nightmare in the election process. We've got folks all over the world that vote in these elections, and to try to police the world to see who is and who isn't is not really realistic.
Any other questions? Jack?
So if there's no motion to include it, it's automatically.
It's automatically, you have to have an affirmative motion to include it. And if there's no further discussion, I guess, Mr. Chairman, you'd call for a motion one way or the other. If there's no motion, it's automatically excluded.
Okay. Is there a motion on the floor to include this paragraph A, 21A? Seeing none, we'll move forward and not include that.
Okay. The next amendment is in Title 21, eligibility to vote. It is, would be C, voting by districts. This would, hold on here. C, this would replace C2, which currently reads as follows. This is the current law. Non-resident registered voters. Every non-resident registered voter shall be registered to vote in only one district and precinct in which he or she selected. A non-resident registered voter shall have the right to vote only for the candidate or candidates for a council seat or seat for which the voter registered for the voter's registered district. That must come out because it's not constitutional anymore. If you're a non-resident voter and you haven't selected one in the first election, you automatically are at an at-large, in an at-large district. So number 2 would have to come out, and it would be replaced by this language. At-large registered voters. Every at-large registered voter shall be registered to vote in the at-large district. An at-large registered voter shall have the right to vote for the candidate or candidates for the at-large districts. That's going to need to change. Okay. We say every at-large registered voter shall be registered to vote in the at-large district in accordance with the Cherokee Nation Constitution, because there are opportunities for first-time voters to choose an at-large district. Correct, Jack?
Yeah. To choose to vote within one of the districts.
Yes.
25.
Jack?
Yes. Now this, we call them at-large registered voters, means they are registered to vote at large. And it does not concern the people living outside the nation that are registered to vote within the nation. You follow me?
No.
Okay. A lady in Oklahoma City that's registered to vote in Rogers County.
Uh-huh.
So she's not considered an at-large registered voter. She would be considered a registered voter in Rogers County.
Okay. Yeah, I'm following you. Yeah. I'm following you.
So she would not be called an at-large.
That's correct.
But we need to clarify to be sure that people understand.
Are at-large registered voters. Every at-large registered voter shall be registered to vote.
Do we need to have a definition of an at-large registered voter?
You know, I'm going to ask that this one be tabled, and I'm going to have to come back to this one.
We got a couple of
Table.
questions. Okay.
Yeah.
Second.
Yeah.
All in favor to table it?
We'll come back to
All
that.
opposed? No.
Okay. The next one is section 11B1. There was right now, it's two election commissioners appointed by the chief, carte blanche, 2 election commissioners voted, approved by the council, carte blanche. Those 4 select a 5th, and that is approved by both the council and the chief. It had been asked that we stagger, now that this is a permanent body and will always be in existence according to the Constitution, that we stagger these terms. So this is my stat at that. Staggered, which would be 11B, creating a new number 1. Beginning with the appointment of an election commissioner of the election commission in October of 2011. So it wouldn't affect this commission right here. They have their terms, but when and that term will expire under the law in 2011. So when you create a new election commission in October 2011, which I believe is the time frame, that the tribal council shall appoint 1 member for a 4-year term and 1 member for a 6-year term. The principal chief shall appoint 1 election commissioner for a 4-year term and 1 election commission member for a 6-year term. Thereafter, hold on, I lost my place. And then the members shall then select a person to be a 5th member of the election commission for a 4-year term to be confirmed by the principal chief and the council. Thereafter, all terms.
Hold your thought there, Todd. Jack?
This does not say anything about the chief's appointments.
I wrote it in here.
Okay.
Okay, I'm going to be asking for an amendment. Okay, that's but that's the idea. Okay, so I would ask for an amendment that says right after it says the tribal council shall appoint 1 member for a 4-year term and 1 member for a 6-year term. Period. The principal chief shall appoint 1 member for a 4-year term and 1 member for a 6-year term. Period. I would ask for that amendment.
I moved it to be amended.
Second.
Okay, we have a second. I have one question. Bill John.
Yeah. And I can see how this would work for this point forward. But if we really want to stagger them, I think we could almost do it by lot of the 2 council appointments or the 2 people that were appointed by the council to draw straws, and whoever got the longest straw would extend their term 2 years, and the same way with the chiefs, and then use this after that's done. I mean, we get to the staggered real easy with them.
Well, I mean, yeah, this idea is for the permanent, the permanent law,
Well, yeah, for the permanent law.
Yeah.
I'm just saying, if we want to get to it quicker, it's pretty easy done.
Okay. Well, this is for the
And then we might want to tweak this law if we decided to do that, because it would be a no-brainer, because at that point, every 2 years, either the 4-year or 6-year term is going to come up to be reappointed, and all of a sudden, the council knows that the 4-year term or the 6-year term is or I guess they'd all be 4-year terms after that. Once we got the staggered, then everybody would be appointed for 4 years.
Well, and then that was a question I was going to have. But I guess first, if we could officially adopt his motion.
Okay.
For the principal chief to do likewise.
Call the question.
Okay. Question's been called. All in favor?
Aye.
All opposed? Okay.
All right. So we got the council doing a 1 4-year, 1 6-year, chief doing 1 4-year, 1 6-year, and the question I have is that do you want these to remain 4 and 6-year terms, or do you want them after this first appointment in 2011? Do you want them all thereafter to be 4-year terms?
It would make more sense to just stagger it in some method, maybe like I said, and then they'd all be 4-year terms after that.
So thereafter, all appointments shall be for 4-year terms.
Yeah.
Okay.
But they just stagger off every.
Well, sure, yeah, we're setting up. However, you all get there to I mean, you could do it by lot, later on, during this term, but my idea is that for a permanent code for future councils to look at, this is how we set it up.
But if we do it by lot, then that permanent code is different.
Well, I guess.
Because you're not going to be appointing them both at the same time, because they'll never come up at the same time again.
Well, I guess at this point then, I mean, you all want to adopt this, you can either adopt this amendment, or we can rework a one that draws lots, but, I mean, we can do it, but I mean.
Well, but if we adopt this one, it'll work one time.
It only needs to work one time. I mean, if you have every four, I mean, if you.
But the law's going to say that the chief's going to appoint one for 4 and one for 6. But it's never going to work like that again after the first time.
Well, that's why we add that sentence, that I wanted to ask you all. Thereafter, all appointments are for a 4-year term.
Okay. Yes, that's it.
Kind
In case of death, which I'm sure that won't happen while we have one in office, but in case somebody did pass on, would the respective body that did the initial appointment be the one that would make the appointment to replace them?
I believe that might be covered already.
Under that holdover clause on 2, we don't really say who appoints that person either.
I believe that was covered, but really for the purposes of this, that is really not germane to this amendment. I mean, we can, at further on in section 11, under G, removal, that could be covered there. And
Do you think it's covered somewhere in here now?
I think that it is. Let's look at it. The election commission shall be appointed by. Okay, where you would more, if you want to specifically define that, would be in section 11B, right above there. Section 11B is defined as a term. It says the election commission shall be appointed as soon as practical, preferably within 6 months following the expiration of the term of the election commission. And that's something we're going to have to change also because of the Constitution. Each election commission shall serve a term commencing on the day of appointment and ending October 1 of the general election year for which he or she served as an election commissioner. A person appointed or selected to fill a vacancy on the election commission shall serve only the remaining term of the vacated position, and we would further define that there. But actually, 11B is going to need work all the way around, I think.
So there's another portion of section 11 that would address that that's not in our book?
Well, for a lot of the pamphlets or the booklets, the books that have been sent out, probably 3 or 4 times we have copied the entire election code. This time we didn't. But, the election code has it under section 11B.
Why don't you put it in there for next month so that we can review it?
Okay.
Judy.
I just wanted to go back to Bill John's point about lots, even though this is going to be a one-time thing and language to add it. And I still think the idea of doing it by lots is a good idea, just because there could be the appearance of favoritism on the part of the council and the executive to one person or the other in terms of who they select for the 6-year term and who they select for the 4-year term. And I think that doing it by lots would eliminate any appearance of favoritism.
Well, then in that case, what I would recommend is no action be taken on section 11B1. That's in your pamphlet. and let us take a crack at developing implementing a staggered term via lots.
Make a motion to table.
Second.
Got a motion, got a second, all in favor of tabling?
Aye.
All opposed? Say aye. Todd, number 2.
Yeah, the second, the next amendment is section 11B2. I was also asked that a holdover clause be put in for the terms of the election commissioners. And basically, what a holdover clause is that a member remains a member until his or her office successor is duly appointed and seated.
Second.
Motion, got a second. Harley?
Question. Do we need to put a timeline on it, Todd?
Nope. That's the whole idea of a holdover.
Just leave it up.
And that's the purpose for a holdover, is that there is no time limit. Concerning inaction by the council, inaction by the principal chief, it is something that is out there. So I mean, it's a good thing to have, but that it also, it can also be abused.
That was my thinking. You may have that holdover in there for 20 years, but I guess it's still doing a good job.
Well, I mean, it can, I just choose not to appoint someone else. Okay, and then you go into. We had that situation with a Supreme Court justice not too terribly long ago, and it took court action to finally get something resolved on it.
No more questions? We have a motion on the floor. All in favor?
Aye.
All opposed? Hearing none? Todd?
The next is amendment would be under section 31, qualification of candidates. And this is housekeeping. We're just changing.
Before we go on, I have one more question. Todd saying, in this instance, and we may be covered some more in this, if the election commission officer resigns, then what do we do?
Now, a holdover clause is not indentured servitude, okay? You can quit anytime you want to quit, and that's just a vacant position.
That's just a vacant
Yeah.
position. Okay,
Yeah.
that answers the question. Thank you.
Okay, Todd?
This next amendment, section 31A, literally just realigns the articles of the former Constitution to the new Constitution.
Jack?
I move that it be approved with one correction under the last line under 1, which said, shall be a member by blood of the Cherokee Nation, change member to citizen.
Yes, I thought I caught all of those.
Second.
Any questions? Don?
Mr. Chairman, I make a motion to adjourn, so we'll be ready for the next meeting.
Okay, well, let's go ahead. Let's vote on this, motion on the floor, then we'll,
Could I ask just one question? Under 31A, Todd, qualifications, the felony conviction there keeps someone from running for office. Is that not true? I mean, that's still in the books, right?
Yeah.
Okay. With that said, I'd like to revisit 21A4 and at least just go on the record or minutes or whatever of being in favor of that, including that in this legislation. And I would make that motion if we could include that at this time. Can we do that?
you want to do can we do a friendly?
We can't?
No.
You can.
Well, what happened under 21, under section 21A4, there was no motion whatsoever.
Okay.
So therefore, it died by exclusion, okay? If you want to propose it as part of it, you would move it, and it would need a second. If it didn't get a second, it would still die.
Okay. Just for the record, I'd like to move to reconsider it. Okay?
Well, so, let's just go ahead and go with just moving it,
Okay.
because it hadn't been considered. Right? I'm asking, I'm looking for a little help.
with it.
Can we clear this one motion out?
Yeah, there is a motion and
Let's
an
get
order on.
this motion.
Yeah.
Jack's motion, and then
Okay?
let's vote on it,
Yeah.
and then we'll move on yours. Okay, all in favor of Jack's motion
Aye.
with changing the citizen?
Aye.
All opposed? Okay.
Well, that was the entire section, with the correction of citizen.
Right.
Was my motion.
Yeah.
31A.
Right. Now, is it appropriate to move back to Joe's?
He can, someone can either adjourn or he can move 21, section 21A4.
I can do that in our next get
Yeah, you
together.
can.
Okay, I'll just pull that for right now.
Okay.
Mr. Chairman, I make a motion to
Okay,
adjourn.
we have a motion to adjourn. Second. All in favor to adjourn? All opposed?